Good afternoon, everyone. It's April 9th, Thursday. All right, we're going to start with, I was thinking, should we start with the harder stuff or the easy stuff? Let's go with easy. I'm thinking we'll go with easy. Yeah. So easy, we have some concurrences with the Senate, okay? So the first bill we have is House Bill 467.
Yeah.
So I'm going to let Claire explain, or either Delegate Embry.
I trust Claire.
Okay.
She's spoken. They're on the same page.
We're on the same page. I like to hear that.
So if you will recall, this is Delegate Embry's bill relating to the Maryland Parole Commission and improvements in transparency and equity. We had passed that. It went over to the Senate. We then got the Senate bill, which was Senate Bill 822. A few days ago, we passed that favorable, and the Senate had added on a piece relating to erroneously convicted individuals, prohibiting a county from being a party to a proceeding for erroneous conviction before the Board of Public Works. So the Senate has amended the House bill to add that so that the two bills would be identical. So the proposed motion would be to concur.
Okay. All right. Do we have a motion to concur, and we have a second? Yes. And are there any questions? All right, seeing none, everyone raise your hand if you are in favor of the motion to concur. All right. And everyone raise your hand if you are not in favor of the motion to concur. Okay. The motion passed. Now we're going to go into, I was wondering when the sunglasses are going to come out this year. Oh.
Yeah, but I actually have.
Oh. Okay, so the next bill is House Bill 11, and I can actually explain this one. Okay, so on House Bill 11, the Senate amended our bill to strike the word shall and put may. This bill on House Bill 11, it's actually okay, because this is Delegate Simmons' bill, House Bill 11, the Anne Arundel County Sheriff Appointment of Majors. And so instead of shall, they put may, and that's not a big deal because this is an enabling bill anyway, all right? So it says may, and then they added that the majors, that who shall serve at the pleasure of the sheriff, and that is so that those individuals would be at-will employees. Okay, Delegate Valentine.
Are they currently, thank you, Madam Chair, are they currently at-will employees now at that rank?
Well,
They don't have them. This is creating that rank? I didn't.
This is creating,
Okay.
Actually, Delegate Simmons, did you want to add?
Yeah,
Anything
so the
with your mic?
Anne Arundel County Sheriff's
Your mic? Your mic?
Oh.
Okay.
How y'all doing? All right, thank you very much. Yeah, so the Sheriff's Department is looking to add 3 supervisory positions under the rank of major to the department, and this will allow for them to do that, working through the county council and the county exec's office.
No, but do they currently have these?
They do not.
They do not, thank you.
Yeah, they do not.
Are there any other questions? Delegate Conaway.
Thank you, Chair. Just to be clear, does Baltimore City have any?
That goes outside the scope of the bill.
Thank you so very much.
All right, any other questions? All right, seeing none, all in favor, I need a motion to concur, please.
Motion to concur. Second.
Thank you, I have a motion, and all in favor of the motion, please raise your hands. All right, looks unanimous. Thank you, the motion passed. We're gonna move to concur there. On House Bill 187, This is an expungement, this is that expungement bill, House Bill 187. And is this yours? Yeah. Yeah, okay. Could you explain that one?
House Bill.
This is House Bill 187.
This is Delegate Taylor's bill on expungement of the no finding and case terminated without finding cases. So if you recall, a few days ago, we passed Senate Bill 320, the cross file with their language changes. Everyone, all the stakeholders seemed okay with what the Senate had done. And so the Senate has conformed the House bill to match that. So the proposed motion would be to concur.
And, yep, we have a motion. We have a motion and a second. And Delegate Taylor, are you happy with the change?
Yes,
Thank you.
thank you.
Delegate Cardin?
I just want to remind everybody that we're going to continue to see problems with automatic expungements in that, particularly in the immigration community, but also in in workforce, where people need to show their paperwork, they lose their paperwork, and they can't then get it again. Can't show that they had a case. They may have to actually show the immigration judge that there was a case, that it was expunged for various and sundry reasons, or an employer that they happen to mention, even though they're not necessarily required to, that there was charges against them, and then they want to find out what the disposition was, and they say, well, I don't have it, but it was expunged. Well, it's very difficult to get those records. That being said, I think expungement's a great idea. I love it. I'm just telling you that I've seen clients that have this all the time, and it's unfortunate.
I agree. It is unfortunate. However, there is no however. I would just say and. In this case, we have to make these folks on par, bring them on par with the other folks who can get an expungement for similar disposed cases. Delegate McComas.
I just have a question of our law enforcement folks. My question is, if they did a records check, let's say the jurisdiction where the person was expunged in the court, okay, expungement means that it's not necessarily destroyed, but would that fact be there in the police records, that they would at least be aware of, that it was there? And then, if they were, let's say they're doing an FBI background check, or they're doing a check for the person to join the police department as a recruit. I'm asking if there's some way that you could get it, that it was, at least the information that it was there, and now it's not there, so it was expunged for the person that.
Are you asking if say, for example, John Doe was in that police record? Is that what you're asking me?
Yeah.
Or
John Doe, if they could look up John Doe.
Delegate McComas, could you use your mic? Nope.
In other words, that they could look up John Doe, okay, and John Doe knew where he was charged, okay, and then went and at least there's
no, any reference to that particular individual who was expunged is removed from the record. So you'll have the police report, but anywhere where that individual's name is mentioned or put into, you're not going to be able to query by that person's name to find that report. You would have the report come up, okay, case number 5,000, but there would be no reference to that individual in that record. It would just be blacked out or removed or redacted or say expunged. You would not be able to trace it with his name.
So, okay, let me ask this other question then. If we have these automatic expungements, that could be a problem if it was somebody that they had several records and several records were expunged, and then.
So Delegate McComas, that is actually outside of the scope of this bill.
Okay, yeah, I guess because there's no finding. Yeah.
Right, and this is also not automatic. This is not automatic.
Okay,
Yeah.
all right.
Okay.
Thank you.
Delegate Moon.
Thank you, Madam Chair. I was going to ask some questions because Delegate Cardin has now confused me because he was making commentary about automatic expungement. And it looks to me like this bill is about expungement by application, correct?
Correct.
Okay.
I'm misstated.
Okay, thank you. Okay, got it. Thank you.
Yep, only by application, and it's merely because this is not, we've been so prescriptive, this is not one of the things that is listed where it says no finding and case terminated without finding. And there was one judge who gave this finding, and we have to correct it so that people can expunge. So, with that said, are there any other questions? And there is a motion to concur, and there is a second. All in favor of the motion, please raise your hands. All opposed? All right. The motion passed. Now we're going to move on to a Senate bill, and then I'm going to go back to House bill. So keep in mind, I'm working on a Senate bill now. So this is Senate Bill 334. Okay, I'm working on Senate Bill 334.
Motion to receive.
And this would be a motion, well, first of all, let's talk about what is happening and what the Senate did. Holly, would you mind explaining what the Senate did? 334.
Okay, so when we sent the Senate bill over, this is Delegate Williams on the House side, but Senator Love on the criminal side. This is the firearms machine gun convertible pistol bill that was just on the floor yesterday on the House side. The Senate, in their bill, had a the Department of State Police shall make regulations and create a list of prohibited machine gun convertible pistols. But the fiscal note was then $220,000, and we needed to get permission, and we found out that the money is in the budget. So now we are going back to the shall. When we sent it over, we had a may. So now both the House bill and the Senate bill will match and be shall. And we have permission. And that's why we're receding.
Okay, hold on one second.
I'll make a motion to recede, Madam Chair.
Thank you. There's a motion to recede so that the House bill, the Senate bill, so they look alike. I like that. So they look alike. Senate bill will match the House bill. Is there any question? All right, all in favor of the motion to recede, please raise your hands. All right. All opposed? Please raise your hands. All righty, the motion passed. So we will recede. Thank you. Thank you for your patience there while we dot our I's and cross our T's. I'm going to move on now to our next bill. We have a House bill. This House bill is House Bill 17, and we need to, this had extensive amendments. House Bill 17, Delegate Cardin's bill. this was extensive. And what they did was change the word which and substitute. And change it to warlock. No, and change the word to, they substituted which with that. That. With that. Okay? So, the, oh, well, just a moment. Page 2. So on page 2. It was on page 2 in line 30.
Which to that? This is like.
I know. Well, as what this is, boys and girls, is a lesson in changing a word can change and slow down the trains. Okay.
But, I mean,
Okay.
it's, they're playing with you, so whatever you want to do to play
Okay.
back.
Yeah, yeah. What were you saying, Delegate Moon? Oh, okay, okay.
It's in the Senate bill already, this
Yeah,
is
yeah.
just technical.
Yeah, yeah.
Yeah,
Yeah,
okay.
Okay,
That's probably better.
yeah. Okay, so members, I would like to know if you would like to concur with the Senate amendments, this technical amendment, if you concur, if you would like to, wait, first of all, do I have a motion to concur? Thank you. Thank you. If you would like to concur, please raise your hand.
Can I know where it does?
Yeah. Okay, what it does is it corrects a grammatical error from the word which to that.
It doesn't change the.
It doesn't change the content of the bill, context of the bill. Okay, could you raise your hands, please, if you're in favor? All right. All those opposed, please raise your hand. Emphatically opposed. So the.
You want to hold it?
All righty.
Does not apply to county that register as opposed to which.
Yes. Anyway, moving right along, you all. Let's move. Let's keep moving. House Bill 187. House Bill 187 is a motion to concur. This is the House version of the Senate bill.
We just did that.
Thank you. 284? We didn't do that one, did we? Okay. All right. Now we're going to move to House Bill 284.
Okay.
This
284?
284. There were amendments made by the Senate. This would be Holly. Holly, could you explain what the amendments do?
Yeah, we have already done this on the House side, or on the Senate side, it came over with this amendment. This is a penalty-related change, and what the Senate did is, they said we just said for a violation, it's $1,000. They broke it out for a first violation not exceeding $250, and for a second or a subsequent violation, $1,000. And we've already talked about this and passed it when we passed the House or Senate bill. This is making it match.
Okay. Thank you. We have a motion to concur the House bill with the Senate bill that we already voted out. Are there any questions? Seeing none, all in favor of the motion to concur on House Bill 284, please raise your hands. All opposed? Motion passed. All right, we're going to move on to House Bill 338. And actually, we're going to hold on 338 because I need someone to be here. We're going to move on to, we've already done that one. Then I'm going to hold that one. Hold on. Just 1 second here. Transfer on death deed. Is this a Holly? Is this? Okay. So this is House Bill 738. And concur.
Second.
Concur. Okay, this is a motion to concur. And can you tell us what the change is?
This is easy. This one's just technical like the other one. This, the two bills, the words are in different order, and it's just conforming the two bills, the House bill and the Senate bill, so they match up. So the Senate bill went over, and we're just matching it, so technical all the way.
Technical all the way. Okay. All those in favor of the technical change, please raise your hand if you would like to concur. All those opposed? All righty, so that motion passes as well.
I think we should accept that one.
All right, let's move on. Yes, I agree. Okay, now we're going to move on, and I'm going to go to these, some more concurrences in just a moment. But right now, I'm going to move on to two bills that, or three bills, that are on our vote list. Okay? You all, I need a little bit more cooperation here. Okay, so the first bill we're going to have is Senate Bill 810. And Holly, would you explain what the bill does? I think we've explained it ad nauseum. Senate Bill 810. This is the Maryland Values Act of 2026.
So we talked about this a little bit a few days ago. Amendment number 1 is technical. Amendment number 2, we've changed it a little bit. You have a new reprint that was just sent to you. We've changed the term judicial officer from the bill. So it strikes the term judicial officer and substitutes covered officer, which was a term that was used in another bill that passed yesterday out of Judiciary. It was Senate Bill 346. So another bill used the same term. It has a very similar definition, so we're altering that judicial officer to be covered officer. And then the amendment also puts back in a requirement that courthouses shall implement a policy which may consider the guidance issued by the Attorney General related to immigration enforcement in sensitive locations. And it requires the courthouses to update that policy as necessary.
So we had accepted the amendment previously, and now we are moving to, I'm sorry. No, you had it right. You said move the amendment. You had it right. Yeah. And there's a second on the amendment. All in favor of the amendment, please raise your hand. All right, all opposed, please raise your hands. All right, the motion carries. On Senate Bill 810 as amended, is there a motion? Are there any questions? Seeing none, please call the roll.
Senate Bill 810, Senator King, Immigration Enforcement, Expanding Sensitive Locations, Notification and Guidance, Maryland Values Act of 2026. The Vice Chair.
Yes.
The Vice Chair votes aye. Delegate Valentine. No. Delegate Valentine votes no. Delegate Embry. Aye. Delegate Embry votes aye. Delegate Cardin. Yes. Delegate Cardin votes aye. Delegate Phillips. Yes. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes no. Delegate Moreno. Delegate Moreno votes aye. Delegate Aricon. Delegate Arcon votes no. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes no. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 12-6-0-0-1. The motion carries.
Thank you very much. Now we're going to move on to Senate Bill 187. And we have amendments.
187.
Oh, I'm sorry. Just 1 second, please. Well, I will say that, just to let you all, we're going to talk about the amendments. There has been a great deal of work that has gone into Senate Bill 187, and this would establish the pre-release center for women that we have not established. It will continue the work that we've already done. So Claire, can you explain what the amendment does?
The amendments replace the term reentry with pre-release in the Senate bill, alter the definition of eligible individual to, in the Senate bill, it was defined as an incarcerated woman who is within 18 months of the woman's anticipated release date and has pre-release or minimum or pre-release status. And this bill, these amendments would change that to within 36 months and has pre-release or minimum security status. The amendments also alter requirements relating to the site and capacity of the facility and the services to be provided. They alter the timeline for the planning, construction, and operation of the facility. They also alter reporting deadlines and make some technical changes.
I'm looking around to see if I see any confused looks. I'm not seeing any. Do we have any questions? Okay, Delegate Taylor.
Page 1, line 22, where we've added has pre-release or minimum security status. Have we had any comment on that with regard to, can we talk that through?
The reason for that is, one, they have similar security levels. So we wanted to make sure we didn't have too much of a mix of security levels. And I believe the sponsors also wanted to have the beginnings of a reentry feel towards the pre-release. I believe that's my understanding.
Have they brought up any concern that once you've added minimum security to it, then it becomes more of a facility where there's a need for fencing and?
Well, oh my gosh, I'm sorry, I didn't mean to say it like that, but yes. Yes, there have been several discussions about security and fencing and things of that nature. And in fact, in the bill, I believe, in the amended bill, I think they actually go into
the way it looks, yeah.
Yeah, what
I read that.
what is available as far as all of that, because the whole, that's what, it's not in the bill, I remember now. The whole point is to not have the fencing and the barriers and all of that. So that has been, so that's why these individuals would be minimum. That's why it says the word minimum security. So, because they would qualify and they would have that status so that they could enjoy the benefits of the pre-release center. Yep, and so just also for clarification, in the bill, they amended 18 months to 36 months.
Yeah.
And they included minimum security status so that that would include those individuals who may not yet be on pre-release status, but would have minimum security status. And it would include more women who could, like I said, reap the benefits of these programs and this facility, and could be in this facility.
Okay.
Yeah.
I get that. I just wonder, as I had a conversation also, that led me to believe that just by using the words minimum security, then we're kind of building something that we weren't intending to build with fencing, with more security features, because it's still a minimum security type. Maybe there are other words we can use or that causes us.
Well, I will say that I would caution any further amendments to this,
Okay,
given the multiple,
I agree.
upon multiple
Yeah, it's been a long time.
amendments that have circulated on this bill.
Okay,
And also, given the work that both of the sponsors have put into this, and also because the Senate is eagerly awaiting this bill to come back so that this can become passage of law.
Okay.
Now, with that said, in no way are we putting out a bad work product. I will state that I don't know what the page number is, but I will, because I might get it wrong, but I will state that it does see a section where it says is architecturally designed and constructed to facilitate the provision of services specified in 3-305 of this subtitle. And that 3-305 might have been where we started in the beginning. Hold on, let's go to 3-305. Well, it just basically goes into the services and more of what, being able to work on the career center and the things that are outlined in the bill. So it doesn't really get into the fencing or anything of that sort. That was part of the discussion. I can tell you, it was part of the discussion, and it was vehemently opposed to put in any level of fencing in the bill.
Yeah.
And as you can see, it's not in the bill. So the parties have worked together and come to this agreement, and this is the work product that has come as a result of their labor.
Yes, and I know a lot of time and effort, and we really want to get this out. So thank you, Madam Chair, for answering my question.
Thank you. Thank you for understanding. Members, do we have any other questions? All right. Seeing none. Oh, Delegate McComas.
Just a real quick question. Because it's still going to be part of the Division of Corrections, I'm just kind of concerned for the security of the folks that are in this facility, but also if they're going to have, like, in other words, they can't stay out all night, that kind of stuff. In other words, is it going to be kind of like a dorm where you sort of check in, you have a house mother that makes sure you're in when you're supposed to be in? I know that sounds stupid, but I mean, my concern is that there's, that there's kind of some guardrails. That's all.
I don't know the answer to that specifically, but I will say that there is a men's pre-release center. Some of this is mirrored after their program. And so I would assume that they would use best practices that they have already, they meaning Department of Correction and Public Safety, would use what has already been used in, with the men's pre-release center. Yeah. Okay. Or the men's program, I should call it, instead of pre-release. All righty. With that said, I need a minute for recess, please. And I'll be back.
There's stuff about security.
Right.
It just says, features that balance physical safety and security with visual privacy and data.
Right. Okay.
It doesn't say anything about fencing.
All righty. We're going to resume this Thursday, April 9th. We're going to resume where we're in discussion on Senate Bill 187. And I just wanted to correct for the record my answer to, I wanted to correct for the record my answer to Delegate Taylor. And that answer, she asked me about fencing, and I probably wasn't very clear on my answer. I might have been actually saying no. But in fact, there will be fencing because it is minimum security status. And minimum security status means just what Delegate Taylor was getting at, and that is there is some level of security. There could be some level of, so there's going to be some level of security. So there's that. I won't specifically say what that level of security is, but there may be fencing. There may be, you know, a tower. There may be some level because we are including minimum security women. Women on minimum security status. So I just want to clarify that for the record. Do we have any other questions? I also alluded to a men's pre-release program. Apparently, there is no current men's pre-release program, so I wanted to correct that as well. There have been, I've seen it with my own eyes, but apparently it's not anymore. All righty. Any other questions? Have I thoroughly confused everyone? All righty. So if there are no questions, please call the roll. And if there's no one in here, if the folks aren't in here, we can circle back to them. Thank you.
Senate Bill 187, Senator Washington, Correctional Services, Comprehensive Rehabilitative Reentry Services, Female Incarcerated Individuals. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes no. Delegate Embry. Delegate Embry votes aye. Delegate Cardin.
Yes.
Delegate Cardin votes aye. Delegate Phillips.
Yes.
Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes no. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes no. Delegate Moreno. Yes. Delegate Moreno votes aye. Delegate Archon. No. Delegate Archon votes no. Delegate Taylor. Yes. Delegate Taylor votes aye. Delegate Simpson. Yes. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes no. Delegate Moon. Yes. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Yes. Delegate Woods votes aye. Delegate Williams. Yes. Delegate Williams votes aye. The tally is 13-5-001. The motion carries.
Thank you. All right, we're going to move now to Senate Bill. Well, Senate Bill 298. Thought we did that one already. Actually, I have it here. Okay. All right. So Senate Bill 298 would be a motion to concur.
Senate Bill 298 is the one, we were gonna pass it favorable, but then we got the concurrence on the House bill where they added something, so we're gonna propose to add that
To the Senate bill.
to Senate Bill 298.
Okay.
So it would be a motion, but they don't have the amendment in front of them, but
Right.
I can just explain. it if you
Okay,
want.
so, hold on one second. So we have an amendment for Senate Bill 298. You all do not have the amendment in front of you. However, Claire will explain it, and it will seem as if it were in front of you.
So we got the House bill back from the Senate, and the Senate has added something. Otherwise, the House bill and the Senate bill, House Bill 338 and Senate Bill 298 are identical, but the Senate added something to House Bill 338, which we were proposing to concur with. And then we would also want to add this to the Senate bill, and it's just a section at the end. It would be section 2, and it would say, before a police officer of the Maryland Capitol Police within the Department of General Services exercises the powers granted under this act in Baltimore City, the Maryland Capitol Police must enter a memorandum of understanding with the Baltimore Police Department.
So, move the amendment. And there's a second. Delegate Conaway, question?
That's a Senate amendment.
That's actually the House amendment.
It's the Senate's amendment to the House crossfire.
And but it's on the Senate bill.
It's The Senate has put it on the House bill. And so we're just going to circumvent the whole back and forth process by adding that on to the Senate bill right now, because we know that's what they want.
And what's who's the sponsor of the amendment?
Senator Hayes.
Okay, thank you.
Just for record that they currently had a MOU already with Baltimore City, so this brings that in alignment.
It's nothing new. They're already in alignment, in agreement with them.
Thank you, Delegate.
Yep.
Okay, we have a motion favorable on the amendment. So just to be clear, the Senate amended the House bill. The motion that we have is to add their amendment to the Senate bill, which is now housed with us, is within our jurisdiction. Are there any other further questions? All right, seeing none. On the amendment, please raise please raise your hand if you're favorable. All right, and you can lower them. That was unanimous. I need a motion to concur the Senate bill to the House bill. All right. Well, conform, I meant to conform the Senate bill to the House bill, yeah. All right. All in favor of the motion to conform the Senate bill to the House bill, please raise your hands. All righty. Thank you. You may lower your hands. You guys are getting tired of raising your hands?
Say concur, just put that on record that we're concurring with House Bill 330.
Okay, thank you. Okay, so we have now approved of the amendment. We voted out the amendment. We are now on the bill as amended. I made you all raise your hands for nothing, but it was good exercise, and you will probably live longer as a result. So please call the roll on the bill as amended. This is on Senate Bill 298 as amended.
Senate Bill 298, Senator Henson, Department of General Services, Maryland Capitol Police, statewide jurisdiction. The Vice Chair. The Vice Chair votes aye. Delegate Valentine. Delegate Valentine votes aye. Delegate Embry. Delegate Embry votes aye. Delegate Cardin. Delegate Cardin votes aye. Delegate Phillips. Delegate Phillips votes aye. Delegate Congolo. Delegate Congolo votes aye. Delegate Stinnett. Delegate Stinnett votes aye. Delegate Simmons. Delegate Simmons votes aye. Delegate Boucher is absent. Delegate McComas. Delegate McComas votes aye. Delegate Moreno. Delegate Moreno votes aye. Delegate Archon. Delegate Archon votes aye. Delegate Taylor. Delegate Taylor votes aye. Delegate Simpson. Delegate Simpson votes aye. Delegate Mangione. Delegate Mangione votes aye. Delegate Moon. Delegate Moon votes aye. Delegate Conaway. Delegate Conaway votes aye. Delegate Woods. Delegate Woods votes aye. Delegate Williams. Delegate Williams votes aye. The tally is 18-0001. The motion carries.
Thank you. So now that we have amended Senate Bill 298 and we have voted out Senate Bill 298, the House cross is House Bill 338. The Senate has asked us to concur with those changes that we had already spoken about that they made. So is there a motion to concur? This is the House. Thank you. Are there any questions? Okay. So this is the House cross of Senate Bill 298, which we just amended and voted out. Any other questions? Seeing none, please raise your hand if you accept the motion to concur. Thank you. It is unanimous. That motion passes. Now we're going to move on to, just one moment. Okay, so we were talking about crim law's third-degree assault, and there is a motion, well, there has been a suggested motion of not to concur with the changes that the Senate put on the bill. So we went over I believe we went over what those changes were, but since it was a while ago, and a while ago meaning, 15 to 20 minutes, I no longer remember. If you could explain what those changes are. Thank you.
It's just basically, the only differences left are just basically technical. Everybody wants to exclude domestic violence victims from the purview of third-degree assault, but there's just a disagreement as to how to word that. And so presumably, it'll just be a quick conference committee where we can agree on that language and get it finished.
So the motion is, yes, okay, is there a second? Is there a second? All right, so the motion is to not to concur with the changes of the Senate bill. Delegate Conaway, did you have a question?
Can we just be refreshed? What did we say and what did they say?
Okay, well, do you want to do it, Claire, or?
Sure,
okay.
unless you prefer to.
Well, you know what, I can guarantee you'll probably do it better.
Okay. It's a question of wording, and it's kind of like bill drafting nerdy stuff. But so I believe everybody agrees that we want to exclude domestic violence victims from, this. If it's a domestic violence crime, it can't be third-degree assault. And so the way that it was worded initially. Wait a minute, let me just look at the Senate. Okay, so the way that the Senate worded it was, offensive conduct does not include an act committed against a person eligible for relief as defined in 4501 of the Family Law article. Well, everybody knows what is meant by that. We're trying to exclude domestic violence victims, but you can't just take that definition from the Family Law article and plug it in here because it doesn't make sense because of the way
It's written.
that's worded. So I spoke with our bill drafting supervisor, and the two of us worked out this language that we think is accurate and correct. And that would be, offensive conduct does not include an act against a person who would be eligible to file a petition for relief from abuse against the defendant under Title IV, Subtitle V of the Family Law article, based on the facts alleged in the application for a statement of charges. So I think the Senate is having a problem with that phrase in the application for a statement of charges. So we can take that out. So we just say based on the facts alleged. So I think that sounds like both houses could agree on that. And then the other difference in the bill is that if you recall, in the bill, there's some model language for a charging document, and that's on page, well, you don't have it necessarily have in front of you, but it says a charging document or warrant for a crime is sufficient if it sufficiently states blah, blah, blah. Well, we decided to strike out the words or warrant because we believe there's not gonna be a warrant
Because
for
sometimes.
third-degree assault.
Because sometimes it just be a charging document, no warrant, right?
And also, a commissioner under the revised bill
Right.
that both houses have agreed on, a commissioner is not authorized to issue an arrest warrant for third-degree assault. But the Senate's version still has that in there, so that's just the other thing that would need to be resolved in conference committee.
Thank you very much.
Sorry that was so boring.
No, it's fine since I'm not going to be on the committee. Thank you.
Well, never say never. All righty. Okay. I believe we have finished the work at the desk. We didn't do that, did we?
Yeah, we haven't.
Okay, I'm sorry? We did everything else except for the motion not to concur on Senate Bill 514. If you agree with the motion, please raise your hand. All right, if you would prefer not to support the motion, please raise your hand. Okay, seeing none.
Madam Chair?
No, I saw a smile afterwards. Okay.
If you're looking.
Hold on 1 second. The motion passed. If you're looking for.
If you're looking for somebody to serve on the conference committee, I am available for the next 2 days.
I appreciate that. Okay.
We did all three, we voted on all three.
We have voted on all three of what?
Yes.
Yes, we have voted on the bills on our list. We have voted on all of these bills. We have finished the work at the desk. All right, we are adjourned.
Yay.